In California law, landlords must follow a series of steps to evict a tenant legally. The eviction process involves filing forms with the court, serving the notice to the tenant, waiting for the tenant to respond or not, and then the final court hearing. Now, there are exact requirements to end a tenancy with different procedures required for different situations. This is just a brief overview of the eviction process. Remember that some communities have rent control ordinances and additional rules in terminating a tenancy may be imposed. Tenants cannot be evicted unlawfully in the state of California. However, a landlord has the right to evict a tenant after failing to pay rent on time. In California's housing law, the rent is considered late the day after it's due, and there is a grace period stipulated in the rental/lease agreement that every tenant must understand. The landlord can then issue a 3-day notice to pay or quit if the tenant has failed to pay rent, which is already past its due. In the eviction notice, there must be no other late fees or interest rates included. Only if the tenants have failed to pay rent after they receive the notice may the landlord continue with the eviction process. So your tenants signed a rental lease agreement, and they have to uphold their responsibilities under the terms of that agreement. If your tenants violate any terms or conditions of their lease agreement, you can issue a 3-day notice to cure violation or move out to resolve the issue and avoid eviction. Tenant violations include things like property damage, owning a pet where it's not allowed, or exceeding the number of tenants allowed. And take note that illegal activity would not fall into another category. The landlord may proceed with the eviction process after their tenants have failed to comply with the original notice. If the tenant commits serious repeat violations, the landlord could issue a 3-day unconditional notice to quit, in which case they'll need to move out 3 days after receiving the notice. In these cases, tenants are not given time to resolve the issue. The landlord can file for an eviction lawsuit if they remain on the property after the 3 days. A few reasons to issue a notice to quit to tenants include but are not limited to being involved in legal activities within the premises, creating severe trouble at the rental unit, irreparable or material damage to the property, or assigning the rental unit to another person or sublet within the unit which violates the rental agreement. In California, landlords in rent-controlled cities cannot terminate a tenancy without probable cause. But in all other areas, if the tenant stays in the property after the lease term has expired, then the landlord may pursue an eviction process. On your screen, you'll see a graphic with the type of lease agreement and its corresponding notice that needs to be received. So after finding probable cause for the eviction process, the landlord can then file a complaint in court to evict their tenants. In California, filing fees range from $385 up to $435, with an additional $40 for a writ of execution insurance. Anyone who is not at least 18 years old and not a part of the case can serve the tenant within 60 days of filing. Otherwise, the case could be dismissed. Landlords can serve the summons and complaint via personal service, where the server gives the tenant the summons and complaint in person, or a substituted service where if the tenant is unavailable, the server can give the court papers to any competent member of the household, in which case the server must also mail a copy to the tenant at the same address. For posting and mailing, the landlord can only use this service if the court gives permission. The server can post a copy of the summons and complaint on a visible part of the property, then the landlord will mail another copy to the tenant's last known address. But the best method to legally serve your tenant is to either send them a letter by certified mail or from a process server directly serving them in person. After serving the summons and complaint, the tenants will be given a chance to respond after receiving a copy of the summons and complaint. So the timeline so far looks like this. The landlords must serve the complaint within 60 days or the court can dismiss the eviction action. So before filing an eviction with the court, you need to issue the tenant a notice to comply. You can either download a free PDF or Word template on our website, or there's a step-by-step wizard that you can use that'll walk you through the entire process to make sure that you are submitting the legally correct notice. Now keep in mind, the step-by-step wizard will ask you to pay a small fee at the very end, but that is a very small price to pay to ensure legal compliance. Imagine you get to court only to find out that you did the very first part of this process incorrect. So you've gotten this far, but before you can evict your tenant, you have to wait for a legally required answer period, and this can range anywhere from 5 to 15 days. Now, if the tenant doesn't respond to your complaints, you would win the case by default. Now, if the tenant doesn't respond, you have a few options. You can ask for a default judgment without a hearing, which can take anywhere from a few days to a few weeks, depending on the judicial officer's schedule, or you can get an immediate order of possession from the clerk of the court office. However, this is only applicable if the landlord is not asking for money back. And remember, these two options will allow their tenants to defend their case if they appeal to remain in the unit. Tenants have 5 business days to respond, and then another 10 days for delivery by mail to complete the 15 days to respond before the hearing process. And upon receiving the tenant's response, the landlord will file a request for hearing within the court. The hearing will be scheduled within 20 days after the hearing request was made. So you made it this far, you won the case. What's next? Well, in this case, the judge will issue a writ of execution so that the eviction process can actually take place. The writ of execution is the last notice that the tenants will receive. This is just letting them know that they need to remove their belongings before the sheriff removes them by force. The writ of execution may be issued on the same day of the hearing upon request, or it may take up to several days to receive. And tenants can appeal to extend their stay of up to 40 days if they file for a stay of execution. If the court grants their request, they will be given a grace period of 40 days to move out. After that period, they have to comply. Failure to do so may result in a forced eviction by the property property sheriff. After the writ of execution has been served to the tenants, they will be given a grace period of 5 days to vacate the property. The sheriff will execute the eviction and forcibly remove them if they remain in the property after the grace period that has been given to them. So at this point in the timeline, tenants have 5 days to move out after they receive the writ of execution. Now, if the tenant disagrees with the request to begin the eviction process, it is incredibly important that you keep good records of everything so you can provide proof to the judge and win your case. Without this, it could be pretty difficult for you to prove and win your case. This can really make or break the entire eviction process for you. Now, you could keep a physical paper trail, but this can get hard to search through, it takes up a lot of storage space, and things could very easily get lost or damaged. What do I recommend? I would say just scan everything into your computer. You can get a great scanner for $300 to $400, and then once you have scanned it, store and back up everything using something like Dropbox, Google Drive, OneDrive, really any option that's easy to use and searchable. Or put it all in one place. Use a property management software. These software allow you to save everything from lease agreements, signed documents, violations, any past emails, reminders, pictures, videos, anything that you can imagine that'll help your case. If the tenant doesn't pay rent and they dispute the claim, it's important that you show the judge the following. 1. Show them your lease agreement, show them the terms of the agreement, when rent is due, and any penalties for a late payment. 2. Show them all of the payments, showing all of the previous payments, how they were normally made, and what date they were normally paid on. 3. Show them any payment returns, any checks that bounced, any time the bank account had insufficient funds, or any time they did a chargeback to dispute on their credit card. Show it all to the judge, and show any fees that your bank may have charged you, including any penalties that you're owed to your lease agreement. And last but certainly not least, show them all of your messages. If you sent your tenant any automated or manual payment reminders, it is important to show this. Because while it's not usually needed, it's still good to show that they were aware of the situation and they were given a chance to cure and make a payment. This is why it's generally best to have everything in writing instead of relying on phone calls and face-to-face meetings. So if you're evicting the tenant for a lease violation, like a noise complaint or unauthorized pets or property damages, it's important that you have proof of that. Well, how do you have proof of that? Well, I'll tell you. Security cameras. If you have a surveillance system that can show them committing the crime or the lease violation, pretty safe to say you're going to win this dispute. But if you didn't catch them in the act, the next best thing you can do is take out your phone and record a video of any damages or lease violations. And last but not least, take pictures, like a lot of them. Even if you take a video, it's still important to show the judge pictures, and it's usually easier to see by email or when it's printed out. So it's illegal if the property has violations in habitability laws. This basically just means that it is not a habitable condition to live in, and the tenant has refused to pay rent because it is not a livable space. It is also considered illegal to evict the tenants if they join, organize, or support a tenants union. Some examples of a self-help eviction include changing the locks, taking away the tenant's belongings, removing the front door, or turning off essential utilities like heat or electricity. But this can also be a ton of other things. Many states actually specify how much a tenant can sue for if the landlord has tried to illegally evict the tenant through some sort of self-help measure. Some state laws also provide for the tenant's court costs and attorney fees if the tenant successfully sues the landlord and/or give the tenant the right to stay within the rental unit. According to California Civil Code, you may be liable for tenants' court costs and attorney fees, and the statute also allows the tenants the right to stay. Plus, the tenant can sue you for actual violations plus damages, and tenants may ask for an injunction prohibiting any further violation during the court action. Thank you so much for watching. I know this process can be a little bit confusing, but I hope this video helped, and be sure to check out this playlist where I talk about other landlord-tenant laws that you should know. Thank you so much for watching. Subscribe if you haven't already, and I will see you in the next one.